Go.
Hi, this is Harvey Nusz. We're doing privacy, setting appropriate expectations, we hope, for 2021. This is a first presentation of a culmination of thoughts that I've had and with some friends of mine about some recent circumstances. So I want to share some thoughts here and see what you think about it. It's somewhat at a high level. We're going to continue to build it out in the coming days and weeks and annotate it with URLs. So I look forward to seeing your comments and questions during the playing of this pre-recorded session. So I am no longer president of ISACA Greater Houston Chapter, now immediate past president as of August 29th. And I want to welcome personally Ted Sherrill, Senior Director of Security and Privacy at Oracle, as our new president. We're going to be in great hands with him. I am, however, still lead for the SIM Houston Cybersecurity, Privacy, and Compliance SIG, and still working closely with the ISACA Houston on privacy programs. So if you want, or if you know someone who wants to be on a panel or speak, you can reach me at privacyshieldgdpr@gmail.com or my phone number 832-858-205. And I want to thank and recognize Robin Austin for her help in preparing this talk. So thank you. So what we're doing here today is we're looking at hearing from you during this to get your questions and learning your comments, discussing your comments and experiences as well via chat, where the state of privacy could be in 2021 next year and why, because of some things that are happening now and have happened, what it takes to get ready, and what could happen if we're not ready, especially if the economy roars back soon and people really start, for some reason, wanting privacy. So I had started to move this back in the deck, but I moved it up front. I thought long and hard on how to navigate the Schrems-ll decision. So some of you are aware of what that means. You know, they've gotten rid of Privacy Shield all of a sudden with no grace period. And standard contractual clauses might be good, might not. You got to beef it up with safeguards. And it's a hard thing to do if you want to get your onward transfer of data here from Europe. So I've come up with the following. And unfortunately, a lot of us feel that's exactly what it's like. So I want to thank Doug Deputy for his help in that and sharing that with me. So where we are now, October. So let's look back in January, February, before the pandemic. We were seeing some companies wanting to get serious about GDPR, getting compliant with that, and with CCPA, which is fairly new at the time, having come into full play, or into play January 1, although into full play June 1 with the AG's rulings. Then the downturn started, the pandemic hit, and all of that just stalled. But now we're coming out of the pandemic, and we're seeing that again now a bit. And we saw the AG finalize the CCPA regulation, adding some new items, not onerous, and not enough to keep CCPA 2.0 off the ballot January 3rd, the CRPA, which basically is GDPR medium. A lot of my friends whom I respect think it may take off across the states, and it's stronger than PIPEDA, the law for Canada, which that law is apparently good enough by the EU. They think it's good enough to have an adequacy decision, more so, which the United States does not have. And just a quick note about that. So that is on the ballot. And if it passes, this is McTaggart's second take on this. He did CCPA, now he's doing 2.0 because he felt that it did not cover the firms that he felt needed to be under the legislation well enough. So it's on there now, and if it passes, then it's going to be law as is. Then on July 16th, Schrems-II hit. So let's look at that timeline starting at the beginning many years ago, quite a few years ago, 9/11, 2001. One of those days that you know where you were when it happened, a tragedy for the US, and it produced the Patriot Act. So NSA was doing what it believed necessary to keep us safe under the Patriot Act and fast forward to 2011, Max Schrems, at 24, Vienna law student, came to Santa Clara University in Silicon Valley for a semester. And of course, they were close to Facebook, so his professor invited Facebook to come in, and Facebook said, hey, here's how we use your data. So Max, fully familiar with the European directive, the laws, the way they handle it, said he didn't like it. Facebook basically said, too bad. Max ended up having the last laugh and then some. There's an article that talks about that. So Snowden then did what he thought was best, exposing all of the surveillance. And then in October of 2015, the European Union Court of Justice, European Union, invalidated Safe Harbor, which previously provided adequacy for the EU 9546 directive, the onward transfer of EU data. So, but they had time then to bring in Privacy Shield to replace it. And so work was done. It was announced in February, but the response was underwhelming, significantly underwhelming. And toward the end of February, it went dark. And then suddenly reemerged in early July with EU approval, of course, stating that if companies signed up for Privacy Shield through the Department of Commerce, they had, by 9/30, they had 9 months to get their contracts signed with their vendors and processors to include the privacy principles. So that was a good deal. Quite a few signed up, and as of today, there are about 5,300 on that roster, which of course is not recognized by the EU now. So the timeline continuing, GDPR went live May 25th, 2018. Excuse me. So then, July 16th, the EU CJ Schrems-II decision declared that Privacy Shield was invalid with no grace period this time. Now, EU was on a holiday, but it really didn't buy us much during that time. They also said standard contractual clauses were deemed not sufficient without technical safeguards along with a contractual agreement. But you should review your standard contractual clauses and your technical safeguards and augment it with encryptions, something to that effect. But they had no comment on binding corporate rules, which is the third way that a company on an intra-company transfer can bring data, onward transfer from Europe to here. So, but on the same day of July 16th, the Department of Commerce had a letter on their website by Wilbur Ross saying, we are very disappointed. We're working on it. Keep up with your Privacy Shield controls. Now, the basis of that are the APEC principles, Asian Pacific. And I remember talking with a couple of privacy guys within the Department of Commerce at one of the NIST framework workshops recently, and they thought that Privacy Shield would prevail because of that, but it hasn't. So let's stop here for a minute, look at a couple of perspectives. The CIOs, I would argue, for the most part, that their point of view at a high level is things are a bit murky now, there's a lot going on, but it'll straighten out, and it'll straighten out soon. And I agree at a high level, but as a friend of mine says, let's look under the hood and see what it looks like now for those who are in the weeds in terms of both privacy regulations and also in terms of technical privacy enhancing techniques to be able to make the SCCs doable. So then, or now, the Department of Commerce has recently issued a letter and a white paper, and it even has a hint of renegotiating at some point, and that may happen. But they also, in their white paper, which defended, how they're doing things, they also included binding corporate rules, and I wondered why. I had no idea, but I did know that privacy pros that I had known for past several years, even 4 to 5 years ago, they've never wanted us to have an adequacy rating because of these. They said we need to have a comprehensive privacy law. They didn't want us to use any of these other binding corporate rules or standard contractual clauses or Privacy Shield. And so I didn't know if it was that or something else. But then I did recently discover that the EDPB, the European Data Protection Board, the old working party, Article 29 working party, in some of their proclamations, they don't believe that binding corporate rules or good either. So it's going to be interesting to see where that goes, because that is beyond the scope of what the Court of Justice European Union has said. Meanwhile, you're struggling to see what that impact has, and as a processor can use both privacy shields and standard corporate standard contractual clauses. You're trying to look at, straighten this out. Where do you need to focus your time and do your risk assessment? Who are your major processors from an onward transfer of EU data perspective? And you're probably asking yourself, do I need to get all that HR data sent here? Maybe you're going to try a new way of doing things. And you need to look at your contracts. Are they signed? Are they up to date? Are they in good shape as well? So the EDPB, the European Data Protection Board, the Article 29 Working Party, they have also issued a document for public comment until this coming Sunday, October 19th, about a 41-page document that includes the following information drawing from the GDPR. Accountability of controllers to define how processors should process the data, and for processors to do that appropriately and communicate as needed with controllers. They also talk about joint processors and have some good additional information. But what really struck me is early on in the document, they have a reminder of the accountability to demonstrate compliance. So for several years now, several of us have talked about compliance on demand, but I'm not sure I know of a company that has really put that into play across their company that includes privacy, security, compliance, and internal audit, that you would be able to immediately respond if a regulator came in the door with a complaint, and to be able to demonstrate compliance. It's not an easy thing to do. So now let's take a quick high-level comparison of GDPR fines versus privacy activism lawsuits. And GDPR fines, for the most part, have not been that heavy. But recently, NOYB, Max Schrems' own organization, recently sued 101 companies regarding the transferring of data via Privacy Shield after Schrems-II said, no, you can't do it. So he locked on very quickly and is suing them for that. Also has filed a suit against Salesforce and Oracle for European Union $10 billion over cookie consent tracking. So the activists are really jumping in here. Now, we can't forget the Irish DPA and Facebook and their little court battle that's going on. And it's going to be interesting to see how serious that gets. But I want to go back to what the EDPB is doing. So they've got this out for comments. And what is the likelihood, I was wondering, talking with some friends of mine, that after receiving comments back from the public and after a sufficient time for consideration of final publication, that they may be starting to urge the data protection authorities in each European Union country, state, the supervisory authorities where there's more than one DPA, and they may start advising them to increase the volume and gravity of the fines now that they have made it crystal clear what the responsibilities and accountabilities are. And don't forget, they could even work beyond the amount of the fines and stop you from sending processing data. Now, let's take a look. Let's remember the major difference about GDPR is privacy is a right. And that means that there's no reason that we should know someone's ethnicity or religion. And it took me 3 to 4 months to wrap my head around that, where it came from, and all of the controls that they have put in place to protect the data subjects. And we also have to remember that this is a huge culture change, because they've recently had a genocide and we haven't. Thank God. Now, what you should already be doing with respect to all of this that's coming forth is data mapping, being able to have mapped your data across your applications, even to your tertiary applications if needed, across your processes and onto your vendors, your processors, and then do some PIAs, I think a lot of people are doing the privacy impact assessments to understand the impact on privacy of the operation that you're planning to do, and even going back to legacy PIAs. And constantly add to your privacy inventory. And you've got data classification in there as well, and categorization. You've got your privacy and procedures, including a privacy policy, and it's a notice when it's out on the website geared to the regulations you're facing, employing tools where needed. And you really need, I think, as kind of the foundation, a privacy framework. And we'll talk about this a minute or two in the next slide. But first, everyone should have a problem statement about where you are and what you still need to do on privacy. But I would argue to turn it into an opportunity statement, and so you can set your company apart by your achievement of secure compliance with privacy regulations. So privacy frameworks, a quick word. Several companies have several frameworks already that they're using, and they're trying to harmonize. And now NIST has come out with their new privacy framework, and I was fortunate in being able to attend all 3 privacy framework workshops held by them. And I do like the framework, and I like it when it's coupled with the cybersecurity framework, because security is a foundation of privacy. And we need to realize that it's a foundation of privacy, but what's happening with privacy over the next couple of years with everything now, I think is really going to set it apart as well. But another way to get a framework is to use the primary and predominant privacy regulation you have, if it's GDPR, if it's LGPD out of Brazil, whatever it is, and it could be CCPA, but to use that and use that as a framework across all of your operations. But another way, kind of building from the ground up, is to use a set of privacy principles. My favorite is the AICPA's 10 generally accepted privacy principles, GAP, with their own objectives. You combine that with privacy by design principles, Dr. Ann Kavukian out of Canada. You can augment it, if you like, with privacy engineering techniques from NIST, and that should enable you to be able to meet 80 to 85% of whatever new privacy regulation will emerge. So fold that into your own internal framework, keep updating it as you need it, back it up with a budget, get your policies, let it feed into everything else, and you should be good to go. Now, if you're using Privacy Shield, that may make it back, but you can't afford to wait on that. So would argue that a lot of companies are probably converting to standard contractual clauses, as Facebook was and is doing. Risk assess them, back them up with an appropriate safeguard, whether it's encryption, tokenization, anonymization, pseudonymization. And one German state, their DPA has said that end-to-end encryption with control of the keys would be appropriate as a safeguard for standard contractual clauses. Not everyone over there agrees with them, but that is one, and so some folks are latching onto that. Some companies are, and using that as a baseline. So binding corporate rules, another way, it's primarily internal to your corporate structure. And if you're using that, keep using it, risk assess them, and augment with the safeguards as well. But do look at your overall encryption compliance and key management strategy, tokenization, whatever you have. You should be able, if you get a regulator walking in the door and said, hey, some data walked out as of a certain day, you should be able to produce a report showing that a particular file was encrypted by a particular method as of a certain day, and be able to show that the keys did not go out the door with the data through centralized key management. It's expensive, but it is a good, very good control. And be sure and manage all keys in the cloud so you manage it and not your cloud provider. And hang in there with Privacy Shield. It may just make it yet. Afterword, one of one. I remember when I lived in Salt Lake City, there was a very nice small restaurant named Afterword. I hope it's still there after all of this. In this time of the pandemic, many people have appropriately not focused a heck of a lot on privacy. You're fighting other alligators. You're trying to stay alive. You're trying to get enough business to keep going, worried about security, working from home, etc. And while we've seen a few bills on privacy now, and some concern on contract tracing, for the most part, we're still willing to sign the EULAs and live in the wild west of privacy in America as compared to the European Union. But I think that could change dramatically when our economy starts roaring back and as customers demand more privacy, as I believe they will. As you know, we were in a privacy revolution, and I think we will get back in that again now. And I really, if you ask me point blank, I don't think we have a lot of privacy, but I think it will be big over the next several years. And we have a lot to go through now with this Schrems and related factors that are happening, and with oncoming privacy regulations through CCPA 2.0, Washington State, I understand Maryland is coming up with some things, and others will, I'm sure. Plus, there's an article in Gartner, a recent article, that says by 2023, 65% of the citizens in our world will have one or more privacy regulations. And by the way, they will not be harmonized. So I would argue that that is a good deal, in the sense that if you feel privacy is calling you, you ought to consider going into this. As I did back in August of 2015, coming off of a good identity access management contract in Keller with Options Clearing Corporations north of Fort Worth. I thought I was going to be in this the next 15 years. But instead, I was able to get into a privacy position, came out of nowhere, and that was in August of 2015, 3 months before the privacy before Safe Harbor was invalidated. And I knew then this was going to be huge. So I started investing in training, starting to speak at seminars, webinars, joined IAPP. And I would argue that you should join that. They will spam you several times a week with very good information. Go for one of their certifications. The CIPM, if you've got a background like mine in security, risk management, compliance, audit, and so forth, project management, it's a good one. It's a good way to get in the door there. So give that some serious consideration. Very much look forward to seeing what all you say on the chat and questions, and thank you very much. Take care. God bless you.